Welcome back. Today, we're focusing about a moment that carries a lot of weight, reviewing and signing your will in a way that ensures it remains valid when it matters. If a will is not executed correctly, it could be considered invalid, and all your careful planning might be set aside by a court. This lesson is about making sure that doesn't happen. Courts care about formalities, the basic rules for how a will is reviewed, witnessed, and executed. So in this lesson, we're doing two practical things. First, you'll learn the why behind will signing rules. Second, you'll create a simple signing plan you can use right away. Who will be there, what you'll bring, and what you'll double check before ink hits paper. First, let's talk about what makes a will valid in the eyes of the law. While state laws can vary slightly, most follow a set of strict ground rules known as formalities. At a high level, most states want a will to clearly show three things. You intended it to be your will, you had capacity when you signed it, and you weren't pressured through undue influence. And then, they want the document signed in a particular way, usually with witnesses, so there's a reliable process that other people can verify later. At a minimum, a valid will must be in writing. In our modern world, this usually means it is typewritten and printed. You may have heard of a holographic will, which is a document written entirely in your own handwriting. While some states recognize these, they are much easier to challenge in court because they often lack the standard formalities that prove you are the one who actually wrote it. There's also something called a nuncupative will, or a spoken will. You've probably seen this in movies where someone shares their final wishes on their deathbed. In real life, these are extremely rare and often invalid for transferring anything other than a very small amount of personal property. For your plan to be secure, you want a formal, written document. Once you have that document, you must sign it. This sounds simple, but the way you sign matters. Most states require you to sign at the very end of the document. This signature serves as your stamp of approval on everything written above it. If you try to change your will later by typing notes in the margins or crossing out lines and writing in the gaps, you could accidentally invalidate the entire document. If you need to make changes, the safest path is to create a new will or use a formal amendment called a codicil, signed with the exact same formalities as the original. The next essential piece is the witnesses. This is where many people make their biggest mistake. To be valid, your will must typically be signed in the presence of at least two competent witnesses. These individuals should be disinterested witnesses, meaning they are adults who do not stand to inherit anything from your estate. If a beneficiary witnesses your will, it could raise a shadow of doubt about your intentions, and in some states, that person might even lose their right to receive their gift. The most secure way to handle this is through a formal signing ceremony. You, your witnesses, and ideally a notary should all be in the same room at the same time. You should tell the witnesses that the document is your will, and they should watch you sign it. Then, they should sign the will in your presence, and in the presence of each other. This clear, shared moment is what proves to a court later that the document is authentic and that you signed it voluntarily. To make the process even smoother, many people include a self-proving affidavit. This is a short, notarized statement signed by you and your witnesses at the ceremony and notarized by a certified notary. It acts like pre-packaged testimony. If your will is self-proving, the court may admit it to probate without requiring your witnesses to appear in person years later to testify that the signing was valid. So, in preparation for this signing appointment, always review your will. This should be the very first step. Before the signing appointment, you want to read your will like a careful editor, not like the person who wrote it. That means you're looking for small errors that can create big confusion later, like misspelled names, outdated addresses, or a person listed in two different ways. Here's a quick way to do it. I call it the 3-pass review. Pass 1, read only names. Every name, every time. Does the spelling match how the person actually spells it? Does it match how they appear on other documents? If you're using legal names for some people and nicknames for others, you may want to make it consistent. Pass 2, read only roles. Who is the executor? Who is the backup? Who is named as a guardian if you have minor children? If a role is missing or unclear, that's a moment to pause and get it corrected before signing. Pass 3, read the big picture. Does the plan match your real life? If something feels off, that's a sign to ask questions before you sign. If it all looks good, proceed with the signing appointment. A will signing is less like printing paperwork and more like creating evidence. You're creating a clear record that says, "This is my will. I chose this freely. I understood what I was doing, and other adults saw me sign it." Each of those statements is very important. The court must know that you chose to sign freely, without being forced to sign it, and that you understand what you are doing when you sign it. This is also called capacity. Capacity is a basic level of mental understanding at the time of signing. It's not about being perfect. It's about being able to understand what you're signing and what it does. If someone later claims you didn't understand what you signed, the timing and the signing process can matter and may lead to a will contest, which we'll discuss more in a moment. And then there's undue influence, which is basically a claim that someone pressured you so strongly that the will didn't reflect your true choices. You don't need to memorize legal tests here. Just remember the practical lesson. A calm signing environment helps. A private, rushed signing with a pushy person hovering may create questions later. A steady signing with neutral witnesses and a clear process may reduce questions. Now, let's look at what could happen if someone tries to win a will contest. A contest is a legal challenge to the validity of your will. Most contests are based on one of three claims: improper execution, lack of testamentary capacity, or undue influence. Improper execution is exactly what we've been discussing: missing witnesses, signing at different times, or failing to follow state rules. Lack of capacity means someone argues you weren't of sound mind when you signed. To have capacity, you simply need to understand that you are making a will, know generally what you own, and identify your closest family members. Old age or physical illness alone does not mean you lack capacity. Finally, there's undue influence. This is more than just a family member nudging you or being persuasive. It occurs when someone uses pressure or manipulation to the point that your will reflects their wishes instead of your own. Courts look at your relationships and whether the distribution of your assets seems highly unusual or suspicious. To summarize, legal formalities aren't just red tape. They are a wall of protection around your legacy. By following these rules exactly, and perhaps even going overboard by using 3 witnesses and a notary, you are making it much harder for anyone to challenge your plan later. You are moving from a place of, I hope this holds up, to, I know this is solid. So, if you've watched this video, you now know how a will is properly created and what landmines to avoid during the signing process. If you are ready for some small immediate steps, if you are preparing to sign a will, write down your signing plan in 1 minute. Where the signing may happen, think of 2 or 3 people who could serve as disinterested witnesses, friends, neighbors, or colleagues who aren't in your will, and whether a notary might be involved. Second, do the 3-pass review: names, roles, big picture. If you find anything confusing, make a short list of questions to resolve before signing. If you have a current will, review it. Are there any handwritten notes in the margins or unclear sections? If you see them, make a note to have those sections typed clearly into a fresh draft. Second, for those who want to go deeper, we have resources and checklists to ensuring you don't important details and to review state laws. You are building something solid, ensuring your plan is usable. Keep up the great work.